This is Michael Popok, Legal AF. You know what gets a lot of attention? The highlights of the New York Attorney General case starting in less than 3 weeks against Donald Trump and all the Trump children who are executives for a civil fraud. Sometimes we also hear about the amount that she's seeking, which is over $250 million, or the amount that she thinks that Donald Trump has overstated his financial condition, which it looks like it's about $3 billion. All of that is really interesting. A couple of points that don't get enough attention. One I've already covered on a hot take, which is this is going to be a bench trial, not a jury trial, because Donald Trump screwed up. Won't go into it here, but Judge Engoron is going to be presiding over this case, not a jury. And that is a big difference, especially when Judge Engoron has already made a series of rulings against Trump and his children, which have been really, really bad for Trump. Like installing a financial monitor, a former judge, to take a look at all of Donald Trump's financial affairs on a daily basis that's been in place for almost a year, finding Donald Trump in contempt for failing to produce documents and fining him $10,000 a day, dismissing or denying Donald Trump's motions to get rid of the case altogether and calling them frivolous. This doesn't bode well for Donald Trump since Judge Engoron is going to be his judge. But put that even aside for a minute. What doesn't get enough attention is the power, the statutory authority of the New York Attorney General under New York law, what power she has, and what the burden of proof is. How hard is it for her to prove her case under New York law? Let's go there. She is bringing this case under a very unique and powerful, robust set of statutes under New York law that we that practice there call 63-12. It's named for Executive Law 63-12, and it gives, through the New York legislators, a broad power to anyone that sits in the chair that's marked New York Attorney General. And New York has had this power for years. It's been on the books for years. It scares the crap out of businesses and business people. There's another set of statutes called the Martin Act, which is also against fraud, usually in securities. That's not relevant here, but the 63-12 powers are. Let me tell you what the powers are, and then I'll tell you what she's seeking, and then her chances of getting it under the case law interpreting 63-12. Here's what 63-12 says. Whenever any person shall engage in repeated fraudulent or illegal acts or otherwise demonstrates persistent fraud or illegality in the carrying on, conducting, or transaction of business, the Attorney General may apply, in the name of the people of the state of New York, to the Supreme Court of the state of New York, on notice of 5 days, for an order enjoining the continuance of such business activity or any fraudulent or illegal act, directing restitution and damages, and in an appropriate case, canceling any certificate filed under and by virtue of the provisions of Section 440. That has to do with business operation. The word fraud or fraudulent, as used herein, shall include any device, scheme, or artifice to defraud, and any deception, misrepresentation, concealment, suppression, false pretense, false promise, or unconscionable contractual provision. So that is her focus. If she finds persistent fraud, continuous pattern of fraud or illegality being conducted by a business, she has the power to shut it down. The State House has not only found that the person occupying New York Attorney General position has the power to do that, but gives them the right and the discretion to go after the company or the people either in a fast track, what's called summary proceeding, where they can get the whole trial done in less than 90 days or 120 days, or through what's called in New York a plenary proceeding, which is full-blown discovery resulting in a kind of a full-blown trial. Takes a couple of years to do that. It's her choice. The New York lawmakers are fine with her if she wants to shut down an organization, get an injunction against them, and get their money from them and give it to victims. She's fine. They're fine if she does that, under a speedy process where the other side the defense gets very little discovery or exchange of documents. But here she chose, which is a benefit to Donald Trump that he won't acknowledge, she chose to go the full-blown discovery plenary trial route. Now, it was up to Donald Trump to within 15 days of a certain date early on in the case to tell the court whether he wanted a jury trial. He missed that date. He got stuck with Judge Engoron, for better or for worse. And so far, it's been worse. But the powers under 63-12 have been defined at its outer boundaries by cases involving Donald Trump and prior fraud. Yes, a prior New York Attorney General, Eric Schneiderman, brought a case against another Trump entity for another persistent fraud. They litigated over the issue, and the appellate court that matters that sits over Manhattan in New York said that 63-12 is a broad catch-all anti-fraud provision that can be used by the New York Attorney General. It's both a remedy and a cause of action, meaning you can sue for it and you can use it as a remedy as the New York Attorney General in your toolbox. And you can go for restitution. You can go for disgorgement, which is taking from somebody, clawing back money that they never should have obtained in the first place. And the case law in this area, including in the case involving Donald Trump's fraud from 8 years ago, he should know this law very, very well, considering he was involved in that case, is the focus is not on the amount of money that he stole from a victim. It's on the amount of ill-gotten gains he put in his pocket. Think about that focus now as it relates to what you've heard about Donald Trump's quote-unquote defenses. He says, well, the banks that I borrowed money from, I paid them all back. Even though I borrowed too much money from them, I paid it all back. See, that's not the focus of a 63-12 case. The focus of a 63-12 case is on how much you made, not how much you stole. And there can be a difference. Remember the charges that underlie this particular case against Donald Trump has to do with, it's sort of like inflation gate and deflation gate. He inflated, according to the allegations of the New York Attorney General, he inflated the value of his real estate through a number of manipulative artifices and fraudulent artifices. Some of it he just did, the square footage of my apartment in New York is 10,000. Let's pump it up to 30,000 square feet and make it like a $300 million apartment. Just so you know, the biggest transaction in the history of New York for an apartment is $140 million for an apartment across the park from Donald Trump's tower. Anyway, put that aside for a minute. So he manipulated the square footage. That's one way. He used fake appraisals. He used made up numbers that had no appraisal component to it whatsoever from an independent party. These were the various ways he pumped up the value. Why? Why did he pump up the value? So he could tell people what his net worth was, so he could make the Forbes 400 or the Fortune 500 richest men in the world, people in the world? No, he did it so he could borrow more and more money from banks based on the value of the property he was pledging as collateral. Banks loan fundamentally, basically, on a loan to value. You might have heard of it, an LTV. Loan to value means we'll give you a certain percentage loan based on the value of the collateral you're giving us. And so if you tell us your property is worth $100 million and we're giving 80% loan to value, we'll give you an $80 million loan on $100 million. But if that property is really only worth $50 million, the bank has lent $80 million on a property that's only worth $50 million, and there's the fraud. Even if he pays the loan back, we don't look to the victim under 63-12. We look instead to how much he profited. So he should never have gotten that loan, or he should have gotten a loan based on the true value, not the made-up, pumped-up value that he used, and that difference is the amount of money that he should not have put in his pocket that the disgorgement or the clawback is going to address. Same thing, that's the inflation gate. Deflation gate, under this context, is he would lower the value of property on these made-up numbers when he needed to pay taxes on them or get insurance on them or whatever. And so this inflation and deflation is the artifice, the fraud, the persistent fraud that the New York Attorney General has the power to stop, either in an emergency setting or in a full-blown trial setting, which is what we're under and what we're watching right now. Now, the New York Attorney General, doesn't have to prove beyond a reasonable doubt that all these things happened. We're in a civil setting. The standard is not beyond a reasonable doubt. It's more likely than not, right? It's that is the standard. It is more likely than not that the fraud happened. In fact, under the case law for 63-12, all she has to show to get, for instance, an injunction against Donald Trump and the Trump organization is a reasonable likelihood of continuing violation under the totality of the circumstances that are presented to the court. That's all she has to show. She doesn't even have to show what we call in the business for injunctions that you and I would have to use, irreparable harm. She doesn't have to show that anybody would be so harmed that money wouldn't fix it. She doesn't have to show that. Why? Because she's the New York Attorney General under 63-12, and the state house, the state legislatures, lawmakers gave her this amazing power and lowered her requirement because they're so concerned with rooting out fraud in the state of New York, especially at the company level. And that's what we're watching. So what we're going to see at the trial is a tremendous amount of powers to get an injunction, to get restitution for victims, to get disgorgement of ill-gotten gains based on the value of how much they've taken, not on the value of any victim statement. Because even if the banks get trotted in there, and Donald Trump's threatened to bring in Deutsche Bank and Capital One Bank and all the banks that he borrowed from and have them say, how much did I borrow? $500 million. How much did I pay back? $500 million. How did you reflect it on your balance sheets of your banks that you repaid your loan and it was in a good loan and good standing? Oh, there we go. I didn't commit fraud. That's an interesting set of questions. It just has nothing to do with whether you committed fraud or not, Mr. Trump. It has to, nor whether you benefited from getting money that you never should have been entitled to begin with. Because under the theory that's used for 63-12, you never should have been able to ask for $500 million. And every dollar that you took is one less dollar that could legitimately be lent by the bank to someone else, right? Banks don't have unlimited funds. They seem to act like they do sometimes. And that's why a lot of banks aren't around anymore today. But they're supposed to have a certain ratio of lending to assets, lending to liquid money that they have on hand. And if they lend out money, it's a zero-sum game. You know, if they made all their loans for the month, there's no more loans to be made. And if Donald Trump took too much money, right, like a pig at a trough, and didn't leave enough for the next person, that is part of the persistent fraud that's being addressed by 63-12. And as I said, Donald Trump should know the case law in this area because he helped make it with another fraudulent scheme that was shut down by 3 attorney generals ago, Eric Schneiderman, where after Donald Trump lost on the appeal, in which the court reaffirmed the right of the attorney general to use the 63-12 powers for injunctive relief and for disgorgement and restitution, he settled his case with Eric Schneiderman, right? He's not going to settle his case with Letitia James because she's seeking the civil equivalent of a death penalty. She wants to put the Trump organization that's been around for 60 or 70 years, starting with Fred Trump, out of business, and all the kids never able to hold a license to operate a business or a corporation in New York. And they don't want that to happen because it's one of their homes, and they don't want the embarrassment of it. And they're going to have to reflect this on all of their applications for future lenders, right? In the questionnaire. Have you ever been convicted of a crime involving fraud? Yes. What was it? A $250 million fraud scheme brought by the state of New York. That's not good. That doesn't get you a new bank account or a toaster when you open your new bank account. It gets you denied. And then you're going to have to go offshore with all your money, which, you know, Jared Kushner already started with his Saudi Arabian fund investment. But, you know, he won't be able to do his banking like you and me in a normal U.S. bank. And that's the result. And that's what she's seeking. Most of the things, and I'll leave it on this for this hot take because I think this is important as you watch the trial. Most of the remedies that the New York Attorney General is seeking under 63-12 are what we call equitable remedies. And they go to the court's inherent equitable authority as contrasted with legal remedies, which are, to be simple, money damages. When somebody sues somebody else and they recover damages, that's a legal remedy. Money is law. Money is legal. If they're seeking an injunction to either prevent something from happening or make something happen by court order, That's an equitable remedy that can only come from a judge, that could never come from a jury. Judges can do under a bench trial, they can do money damages, or they can do injunctions, because they sit in law and in equity. But juries are really only for money damages and only for legal issues. They don't sit in equity. All of the remedies she's seeking under 63-12 are equitable. Disgorgement, equitable remedy. Injunction, equitable remedy. Restitution, equitable remedy. The cancellation of the certificate to do business, the death penalty issue, equitable remedy. So even if there was a jury involved, and there isn't because Alina Habba didn't file her paper 2 years ago within the 15-day deadline, they would only be evaluating witnesses and helping the judge develop facts. At the end, it would be up to Judge Engoron, one way or the other, about all of these equitable remedies that we've been talking about. And I'm not sure it's $250 million. We keep talking about it that way. But given the fact that under recent updated filings that Letitia James just made, where they think the inflation gate part of the prosecution, the civil case, is upwards of $3 billion, right? There's an argument to be made that it's multiples of $250 million that she's ultimately going to be asking Judge Engoron for, who is currently, as we speak in this hot take, sitting on summary judgments that he could rule tomorrow, the next day, later in the week, or could go against Donald Trump and give and deny him the right to a trial outright. Because again, everything that he's sitting on are within his powers in law and equity to issue. He doesn't need a jury. He doesn't even have to have a second trial for jury for damages, because we're not seeking damages under 63-12. The New York Attorney General is seeking equitable relief. Kind of mimics damages because it has to do with money, but it's taking his money away from him, and that is an equitable remedy. We'll talk more about these things on Legal AF, the leading politics and law podcast. Only one place, same place as here, the MeidasTouch Network and their YouTube channel. Free subscribe, help them get to 2 million. It helps, and it helps with this content coming to you. You can follow me, Michael Popok, on all things social media at MS Popok. Until my next hot take, this is Michael Popok, Legal AF.
Hey, Meidas Mighty. Love this report? Continue the conversation by following us on Instagram at MeidasTouch to keep up with the most important news of the day. What are you waiting for? Follow us now.